This module is entitled Pre-Hearing Preparation. I'm Adam Wolkoff, the Assistant Director of the Student Conduct Institute. Well-designed and rigorously followed pre-hearing procedures ensure that your institution will provide due process to all parties in a disciplinary proceeding. Long-standing case law concerning due process, along with specific requirements set forth in federal and state law, mandate that parties to a disciplinary proceeding receive adequate and timely notice of the charges against them. This notice has to be sufficient to allow them to prepare a meaningful response. Along with notice, institutions have to be aware of a variety of other compliance issues in preparing for the hearing, including accommodating the parties' schedules, ensuring access to advisors, and providing equal and reasonable access to evidence. This module is designed to provide compliance standards in drafting, serving, and amending disciplinary charges for all types of conduct discipline, with particular attention to the requirements for sexual and interpersonal violence cases. Courts have raised several red flags when it comes to filing charges, and I will draw your attention to these cases and the lessons we can draw from them. Second, we will discuss compliant practices for scheduling hearings. We know that scheduling is one of the toughest parts of the pre-hearing process, as it is a major challenge to coordinate the needs of the many people involved in a hearing. This module will cover the law and strategies for handling this often contentious process. Third, we will cover other preparations for a successful hearing, including issues emerging from advisors, evidence, and student privacy. Note that when it comes to pre-hearing preparations, the Title IX final rules should not significantly alter your existing processes for notifying the parties of charges, scheduling hearings, and arranging other connected issues. Those rules were issued in final form on May 19, 2020, and are effective on August 14, 2020. Where the final rules clarify existing law and best practice, we will let you know. The first issue to consider is the timing of the charges. Always start with your code. Students must be notified of charges within the timeframes set forth in the Code of Conduct. These timeframes must be sufficient to allow the students enough time to prepare a response to the charges, while also not resulting in undue delay in resolving the complaint. For example, in a benchmark 1987 case arising from academic dishonesty, Nash versus Auburn University, the 11th Circuit Court of Appeals held that the accused student received constitutionally adequate notice by receiving about 6 days from the initial notice to prepare for a hearing. Although 6 days is a quick turnaround, the court noted that they knowingly agreed to the timing through the assistance of counsel. But cases arising from more complicated facts, particularly those involving sexual and interpersonal violence, demand a longer time frame between notice of charges and the resulting hearing. When it comes to timing, it's critical that the respondent receive the notice of allegations before any investigative interview takes place. In the Department of Education's preamble to the Title IX final rules, it emphasizes the importance of notice before the investigation. The department notes that, without knowing the scope and purpose of an interview, a respondent will not have a fair opportunity to seek assistance from an advisor of choice and think through the respondent's view of the alleged facts. As a pre-interview notice of allegations is mandated under the Title IX final rules, a school's failure to offer it could be a procedural irregularity that would be grounds for granting an appeal. The department also sees this process as beneficial to the complainant, who can see and understand how the school has framed the allegations so that the complainant can prepare to participate in the grievance process in ways that best advance the complainant's interests in the case. First, we will go over what needs to go into the notice of charges, how it should be submitted to the parties, how it can be amended, and the red flags to watch out for when dealing with notification and charges. What happens if, during the course of an investigation, the institution decides to amend the charge letter? The law says it's free to add new charges, but the respondent has to have enough time to review and respond to them. Again, there's no bright line rule about what's an adequate amount of time to respond. The level of detail in the new charges and the time for response must satisfy constitutional and statutory standards, as well as the terms of the Code of Conduct. Take the case of Tanya v. Appalachian State from a North Carolina federal court in 2015. In that case, the respondent was charged with sexual assault. But on the day before the hearing on that charge, he was notified that he was also being charged with sexual harassment. The court held that 24-hour notice was not enough because the respondent didn't have enough time to mount a defense to that new charge of sexual harassment. Assuming that your charges are filed in a timely manner, they also need to be properly served. Obviously, the complicated rules of process governing civil proceedings don't apply here. There's no legally required method for notifying students of disciplinary charges, but we recommend the use of official, institutional email accounts, as students generally agree to monitor these accounts when they enroll in the institution. Courts hold that a student's receipt of notice through email is adequate to satisfy constitutional due process because, as a Connecticut trial court wrote in a 2017 case, Lang versus Southern Connecticut State, any reasonable college student in the respondent's position would anticipate that important information regarding their status as a student, whether it be in regards to academic, safety, or disciplinary reasons, would be sent to their university email. Notice is sufficient even if the respondent rarely checks their email, because the respondent was on notice of the university's procedures. Moreover, by using email, the institution maintains data showing when notice was sent, thereby demonstrating compliance with the timelines published in the Code of Conduct. If the institution sends notice through email, it can also physically serve notice to an on-campus mailbox or residential address, but that kind of dual notice is not necessary as a matter of due process. Some institutions will send the notice of charges by mail. Again, we don't advise this as a primary method of notification because of the length of time it takes to send and receive a letter and the possibility that the document will be lost in the mail. Now, courts, including the Ninth Circuit in affirming the decision of Harrell v. Southern Oregon University in 2012, have held that if a notice is sent to an address provided by the student when they enrolled, then the student may not be able to claim a due process error from not receiving the notice. But this reasoning raises red flags, because many students will provide a home address where they do not actually live during the semester. We can't rely on notice by sending correspondence to a student's parents' home. So other courts, like the Federal District of Delaware in Terrell v. Delaware State, have held that even where a university sends 2 certified letters to a respondent, that student could still claim a due process violation if the student claimed to have not received those letters. The bottom line is that you should not rely on postal or hand delivery as the primary method of notification. Always use the student's official university email account. So what is adequate notice? In the often cited 2005 case of Flame v. Medical College of Ohio, the Sixth Circuit Court of Appeals expanded on the requirement of adequate notice in student conduct proceedings. To have a meaningful opportunity to prepare for the hearing, students must receive sufficient notice of the charges against them. These requirements are highly specific. The charge letter must indicate when and where did the alleged violation occur. What specific conduct is alleged to have violated the code? What specific code section or sections have been violated? And who was the alleged victim, if any? The alleged victim need only be identified once in the initial charge letter, and then can be identified through initials or as simply the reporting individual in all subsequent correspondence. The Title IX final rules follow these standards of notice and add requirements regarding the presumption of non-responsibility in false statements. The final rules require notice of the allegations of sexual harassment potentially constituting sexual harassment as defined in Section 106.30 of the final rule, including sufficient details known at the time and with sufficient time to prepare a response before any initial interview. Sufficient details means the identities of the parties involved in the incident, if they're known, the conduct allegedly constituting sexual harassment under 106.30, and the date and location of the alleged incident, if it's known. The written notice must also include a statement that the respondent is presumed not responsible for the alleged conduct, and that a determination regarding responsibility is made at the conclusion of the grievance process. The written notice must inform the parties that they may have an advisor of choice who may be, but is not required to be, an attorney, and may inspect and review evidence. The written notice must inform the parties of any provision in the recipient's code of conduct that prohibits knowingly making false statements or knowingly submitting false information during the grievance process. When a public college or university fails to provide adequate notice, it may violate the constitutional due process rights of the student. But effectively, the same principles bind private schools, which may be sued in a breach of contract or Title IX action for failing to follow its own procedures or failing to provide a fair process to the parties. So we have identified some red flags to look out for when drafting and issuing charge letters. First, you should never issue a charge without supporting facts. It's not enough to tell the student that they have violated a code section. The student must know exactly what facts gave rise to that violation. Second, the charges must identify the reporting individual. Again, the reporting individual need only be identified once, but the accused student needs to know the identity of the accuser to be able to prepare a meaningful response. Third, when presenting the charges, campus officials must act as neutral parties. Campus officials should never make statements showing an assumption of guilt. In the 2017 case of Mancini versus Rollins College, for example, a public safety official allegedly had an initial meeting with the respondent when he made repeated accusations that the respondent raped the reporting individual. The court identified these circumstances as one where the campus official may cross the line between a permissible pro-victim orientation to an illegal anti-male bias through hostile statements to the accused, demonstrating an assumption of guilt before the investigation or hearing. A fourth red flag may appear if there are multiple incidents. If the respondent is being charged with multiple incidents of sexual assault, each one must be identified specifically. For example, if the parties are in a long-term relationship, it's not enough to charge that non-consensual sexual activity occurred continuously or through a number of incidents. Each incident has to be separately identified. A leading federal case on this issue is the George Mason case, a 2016 decision from the Eastern District of Virginia. In that case, the respondent and the reporting individual were in a long-term romantic relationship that included BDSM sexual practices such as biting, choking, spanking, or the use of restraints. After the reporting individual filed a complaint, the respondent received multiple charge letters, including one sent by the reporting individual, which did not clearly apprise him of whether his entire dating relationship with the reporting individual was at issue or only one discrete incident, and did not adequately apprise him that he was also being charged with sexual misconduct. Adding to the deprivation was the fact that the hearing panel itself only believed that the same single incident was at issue and not the range of incidents that the respondent was ultimately found responsible for. The court held that due process does not allow a hearing board to generate post hoc justifications for their missteps through claims that ambiguous phrases like continuing conduct or a number of violent and harassment incidents served as adequate notice. The respondent must be notified of the specific factual basis on which they can be held responsible. Finally, a fifth area of concern are charge letters that muddle various charges or legal theories together. A school cannot generally charge a student with sexual misconduct when it really means sexual harassment. If the school intends to charge both sexual harassment and sexual assault, it must name both of those charges independently and identify what conduct supports each charge. Now that you've drafted an effective and compliant charge letter, let's go over the issues that can arise from scheduling meetings and the hearing, and providing adjournments to the parties and their advisors. Courts recognize that tight timeframes are common in disciplinary hearings. In scheduling meetings and hearing dates, institutions must achieve a fine balance. Rushing the deadlines risks an unfair outcome by limiting the parties' ability to gather evidence and be heard. Stretching them out compromises the institution's duty to promptly respond to the allegations. An institution should first consider the timelines specified in its code of conduct. Where the code sets forth specific deadlines, an institution may commit a procedural error in failing to follow them. As a side point, check your code of conduct to see whether the deadlines are based on calendar days, business days, or school days. Because the student conduct process is a year-round obligation, an institution may consider using calendar or business days. but school days may be a more practical measure, as witnesses, advisors, and conduct officials may be unavailable outside the semester terms. Institutions should also determine if the deadlines give the parties reasonable time to prepare their cases, which, depending on the severity of the charges and potential sanction, would include enough time to retain an advisor, obtain and review the evidence, and secure witness testimony. Courts have offered a range of opinions about what constitutes sufficient time to prepare for the hearing. In U v. Vassar College from 2015, a federal district court in New York held that a respondent charged with sexual misconduct was not denied due process, where he was given 8 days between notice of the charges and the finding of responsibility, or 3 days between the presentation of the evidence in the hearing file and the hearing. But such a quick turnaround is not acceptable in most cases of sexual and interpersonal violence. The Title IX final rules don't give or require a specific number of days between the notice of charges and the hearing, but plainly it will be a significant amount of time, and much longer than a week. The notice of charges must be followed by an investigation, an opportunity for the parties to review and inspect evidence that's directly related to the allegations, a 10-day period by which the parties can respond to this evidence, and also time to review and respond to the investigative report. Details of that investigative process will be covered in a separate module. In general, the Title IX final rules attempt to balance the expeditious and thorough investigation of complaints with the need to accommodate good cause developments that justify a delay. The Department highlights as an example of potentially justifiable delays as the need to temporarily accommodate an ongoing law enforcement investigation, or delays attributable to technological glitches, delays owing to the need to accommodate academic issues, such as moving a hearing date because of a scheduled exam, or disclosed disabilities. Basically, the Department of Education's expectation is that each school will set forth its timelines in its code of conduct and follow them, except where good cause arises, and will account for the delay in its record keeping. The department makes clear that administrative overload is not good cause. It won't look kindly on the excuse that a process was delayed because the school did not have the institutional capacity to investigate and adjudicate the matter. It's not good cause, according to the department, if an institution simply mismanages its resources. Also, a school cannot allow indefinite delays to continue simply because necessary witnesses are unavailable. The final rules provide specific steps that the school has to take if it cannot gather relevant evidence in a reasonable manner, or proceeding with the investigation and hearing without that desired evidence. A hearing may occur even where a party refuses to cooperate with the process, and a decision regarding responsibility may be made in the absence of a party at the hearing. Coordinating the many parties to a disciplinary hearing is tough. A request for an extension can unravel your planning and create delays that disrupt the ability of students to obtain recourse or present their defense in a timely manner. If your code doesn't already say so, you might consider amending it to specifically limit the ability of parties to seek extensions except for good cause. In other words, the parties and their advisors must follow all deadlines in the process and request an extension of a predetermined length, such as 5 days, from a designated official. That official can only provide a one-time extension for good cause. Once an extension is given, all parties must be notified in writing of the delay, the reason for the delay, and the date of the new deadline or event. We know that advisors often seek adjournments. Under Department of Education regulations implementing the 2013 reauthorization of VAWA, an institution does not need to cancel or delay a meeting simply because an advisor cannot be present, but it must give proper notice of the meeting. Still, the Department of Education will encourage institutions to consider reasonable requests to reschedule. When it comes to access to advisors at the hearing itself, the Department of Education notes in its preamble to the Title IX final rules that a temporary delay of a hearing caused by a recipient's need to provide an advisor to conduct cross-examination on behalf of a party at a hearing may constitute good cause for a delay. In other words, it's not a mere administrative convenience that would be unacceptable under the final rule. The department cautions, however, that if a school is aware that it might need to accommodate a delay for an advisor, or to actually provide an advisor to a party who might not have one at the hearing, it, quote, ought to take affirmative steps to ascertain whether a party will require an advisor provided by the recipient or not in advance of the hearing so as not to delay the proceedings. Assuming that the institution is not bound by particular restrictions in the Code of Conduct, it retains broad discretion to grant or deny adjournments. For example, a New York appellate court held in Fain v. Brooklyn College that an institution may decide to proceed in a disciplinary proceeding during the summer, if the school was in session during those months, even if the respondent was not registered for classes during that term. Or, as in the 2019 Second Circuit Court of Appeals decision in Doe v. Colgate University, a university did not violate a student's rights where it denied an extension for more time attributable to that student's own delays in reviewing the evidence. But this discretion is not unlimited. Most recently, the New York Court of Appeals held that an institution abused its discretion when it denied a 3-hour adjournment requested by the respondent's attorney. In that case, Bursch v. Purchase College, the respondent retained an attorney to serve as an advisor, as permitted under the institution's Code of Conduct, but failed to provide the attorney a release form pursuant to the Family Educational Rights and Privacy Act of 1974, better known as FERPA. The attorney could not communicate about the case until 2 days before the hearing, when he received a FERPA release. The attorney then asked for an adjournment, which was permitted under the code, based on a scheduling conflict on the morning of the hearing. The college denied the attorney's request without explanation, and followed up with an email to the respondent stating that it could not accommodate the request because the witnesses and evidence were lined up for that time. On the first round of appeal, the New York Appellate Division's Second Department held that this denial was not a due process violation because there was no constitutional right to be represented by an attorney at a disciplinary hearing. It also found that the college's actions were not arbitrary and capricious or an abuse of discretion because it retained the discretion to grant adjournments. The respondent was responsible for the delay, and rescheduling the hearing was not practical with only 2 days' notice, as it involved the participation of 3 faculty or staff members serving as the administrative board, 8 testifying witnesses, including the petitioner and the complainant, and a support person for the complainant. In other words, it would create a logistical mess. But 2 judges dissented, pointing out that the Code of Conduct permitted a one-time request for adjournment, and asserting that the denial of an adjournment infringed on the respondent's right to an attorney in a case where he faced possible expulsion and maybe even criminal charges. The dissenters also pointed to the college admission that it could have compelled the witnesses to attend at a different time or obtain their testimony through a written statement or telephone. And it identified points on the record where the respondent would have benefited from legal advice. Ultimately, the New York Court of Appeals sided with the dissenting views, holding that denying a 3-hour adjournment to accommodate the respondent's attorney was an abuse of discretion and remanded the matter for a new hearing. While the High Court did not explain its thinking, the outcome might be seen in the balance of interests. The potential inconvenience to the college and the other parties to the proceeding was relatively minor, while the deprivation was heavy. The respondent lost access to an attorney, which was guaranteed under the code and the law, and that loss was prejudicial to the case. In striking that balance, then, schools must be careful not to abuse their discretion in providing adjournments, particularly when statutory or due process rights are at stake in the decision. Now, let's briefly cover a few other items to prepare before the hearing. First, let's consider the role of the advisor. While there's no constitutional right to an advisor or attorney in student disciplinary proceedings, they have become the norm, and in cases of sexual and interpersonal violence, a right created under the Violence Against Women Act. All parties have the right to an advisor of choice, who may be an attorney, in all disciplinary meetings and hearings. Once you determine who the parties' advisors are, the students must provide FERPA waivers to them if they want their advisors to receive correspondence from your institution about their disciplinary case. We do not want to be in the position of the parties in the Bursch case, where the attorney advisor did not receive a FERPA waiver until 2 days before the hearing, which understandably made it difficult for the attorney to prepare for the hearing and accommodate it to their schedule. Under the Title IX final rules, institutions may continue to put reasonable restrictions on advisors that are applied equally to the parties. However, they must allow the advisor to conduct live cross-examination on their advisee's behalf at the hearing. More detail about the advisor role and cross-examination will be provided in separate modules. What about the investigation itself? We will tackle this topic in much more detail in other modules, but the quick answer is that before any fact-finding, it's the institution's job to investigate the facts and compile evidence. Once the institution gathers the evidence, all parties have access to the evidence on equal terms. But this access is not the same as discovery or disclosure seen in criminal or civil contexts. Schools have significant flexibility when it comes to sharing evidence outside of the Title IX context, but where the investigation concerns Title IX sexual harassment, the specific procedures for evidence sharing outlined in the regulation must be followed, including the disclosure of relevant evidence that is directly related to the allegations, and the minimum 10-day inspection and review period. Finally, I'll briefly review the process for seeking disability accommodations before the hearing. As we discuss in the module on disability accommodations, parties should be informed that they need to ask for accommodations before the hearing. If the student does not ask for the accommodation before the hearing, they cannot claim a violation after the fact. While the law does not require the institution to provide an affirmative offer of accommodations, it's a best practice and most fair to students for the institution to let the students know what is available, and then give the students the chance to ask for them. Students can be accommodated in a variety of ways through the conduct process. For example, they can be allowed to give written rather than oral testimony. They can be provided additional time to respond to questions, or regular breaks to handle cognitive overload, and they can be given auditory or visual aids. It remains unclear whether a party can be allowed to provide written testimony in a Title IX hearing, as the final rules require oral testimony. That appears to conflict with the ADA, and so in all likelihood it would not be a Title IX violation to accommodate a disclosed disability in this manner. But it remains to be seen whether the Department of Education would consider this type of accommodation as a fundamental alteration to its mandated process and therefore not permitted.